the Sharia, usually but not very happily translated as Islamic law. I say not very happily because it includes personal things like how you pray, which Westerners wouldn't usually regard as law at all. In a Jewish context, they would be regarded as law. The word Sharia simply means a road or a way, rather like Sunnah itself. Now, for a variety of reasons, most of which were consequent upon the fact that the early Muslims had hardly had time to assimilate this body of law and general legal and moral guidelines when they found themselves ruling an enormous empire which entailed decisions infinitely more complicated than any that seemed to be immediately addressed by the text of the Quran and the Sunnah. It became evident that the religion didn't just need a law, but it needed a system of jurisprudence. In other words, a generally accepted methodology by which the rules and regulations of the religion, whether these pertained to how you fast in cold climates or how you deal with marital situations that hadn't been envisaged apparently in the original revelation, that the religion needed a methodology in order to extend these initial primordial principles to extraordinarily diverse and, in the great majority of cases, far more civilizationally and legally sophisticated urban cultures which the religion had now overrun. So we say that the Sharia does not just have two sources, the Quran and the Hadith. The Sharia has about 7, 8 or 9 sources, of which the first two sources, the Quran and the Hadith, are simply the fundamental ones, and the others being derivative. Fundamental sources of Islamic law. So the idea is that where you cannot discern God's preference on a particular topic from a Quranic verse or a convenient hadith, you have to use a methodology of jurisprudence that will enable you to figure out what is the correct moral and religious ruling upon that new topic. And I'll give you a list of at least the most prominent of these. And as we'll see in a few minutes, the relative significance of these and the mode of their application can vary quite substantially from tradition to tradition in Islamic law. And again, another stereotype that it's important to knock on the head is the idea that there is such a thing as Islamic law, because really there isn't. There are Islamic laws and there are Islamic legal methodologies. But again, because of this familiar principle of the religion not having an overriding orthodox magisterium, there has never been one Islamic law. There are schools of Islamic law, 4 orthodox ones, which I'll talk about shortly, and a large number of variants, and also nowadays all kinds of reformist tendencies. So when journalists in particular say such and such a thing happened in such and such a country because of Islamic law, then that journalist is simply parading his or her own ignorance, because almost invariably you'll find some other view in some other tradition of Islamic law that says something quite different. It is a polyvocal tradition, to use the trendy term. So after this we find usually the jurists list as the next most significant source of Sharia something called Ijma, which means consensus. The Prophet is reported to have said that my community cannot agree upon an error. And from that hadith, the jurists deduced that if the entire Muslim world has agreed that such a thing is pleasing to God, then it's pleasing to God. The kind of vox populi, vox Dei idea, because the community is God's community, rightly guided. It's not possible that it could be absolutely astray. So if every Muslim jurist is agreed that a particular thing is halal, then that thing is halal, on condition that it doesn't violate something that's clearly there in the Quran and the Hadith. Now, exactly how this is to be operationalized has long taxed the minds of Islam's jurists. And incidentally, this topic of Islamic jurisprudence, or usul al-fiqh, is probably that area of traditional Muslim scholarship that has been both the most original and the most brilliant and the most prestigious in the Islamic world. Some of the traditional branches of Muslim scholarship clearly have parallels in, and in some cases clearly partly derivative from, earlier traditions in other civilizations. But when we talk about Islamic law, really we are talking about something new. These various secondary sources of Islamic law don't have obvious precursors, say in Roman provincial law or in Zoroastrian law. This is one of the innovations in world civilization that can legitimately be laid at the feet of the new religion. So Ijma, one of these principles, and of course, although everybody agreed that yes, if everybody agrees something is in the law, exactly who everyone is has been a topic of hot debate. Does that mean every single Muslim, including the butcher, the baker, and the candlestick maker on the street of Baghdad, are they really to be relied upon in such weighty matters? Generally, the view is that if all of the scholars of the religion are known to share a particular view, then that view is part of the religion. This doesn't just apply to questions of law, but can also apply to doctrinal questions. Although generally, Ijma is not so frequently invoked in matters of doctrine, because doctrine, unlike law, is spelt out in considerable detail in the Quran and the Hadith. So Ijma, hugely important. Obviously, the drawback is, in a pre-modern society, when it takes a year to travel from one end of the Islamic world to the other, how on earth do the jurists know that everybody agrees on a particular topic? So in practice, the principle, despite its practicality and its clear, if you like, democratic potential, hasn't been actualized as much as you might think. Nowadays, it's invoked a lot more by Muslim reformers because in an age of mass communication, it's physically possible for the first time to discern at least whether any loud dissenting voices are being raised on a particular subject. So that's principle 3 in Islamic jurisprudence. And the next one, and really the last of the really significant ones, goes by the name of Qiyas. Qiyas means analogous deduction. In other words, the jurist, if he is confronted, for instance, by the phenomenon of heroin, obviously he won't find a prohibition specifically naming heroin in the Quran and the Hadith. It's too new, really, for one to be able to claim an ijma. So how can one tell if the religion approves or disapproves of heroin consumption? And the jurist, what he does, so as not to leave this simply as a scandalous blank in the Muslim moral lexicon, applies a process of analogy. And in this case, the analogy is pretty easy and uncomplicated. The Quran doesn't mention heroin, but it does mention alcohol. And alcohol is known to have been prohibited because it brings about a coarsening of the mind. And the Prophet said the noblest thing God has created is the mind. The word for wine in Arabic, khamr, is related to the word khimar, which is a veil. In other words, it veils one's mind and hence makes one less of God's representative on earth. So if that is the reason why wine is prohibited, as it clearly is, then since heroin has analogous effects, perhaps even more intense, then heroin clearly has to be discouraged by God and comes under the heading of prohibited substances, and ditto for all other narcotics. Islam doesn't actually distinguish between alcohol and other narcotics. So that's how the principle of Qiyas works. That's a very crude thumbnail sketch. In fact, Qiyas is the most complex and brilliant of the departments of Islamic jurisprudence. There are endless divisions and subdivisions of Qiyas. The jurists frequently will argue whether an analogy drawn with an apparent Quranic precursor is a valid one or not. But almost all of the classical Islamic jurists acknowledge that, yes, if we're not to leave Islam with an increasing number of lacunae or blank spaces in its law, then we have to have a principle of Qiyas. And obviously, this is, if you like, a reformer's principle. Islamic law is, of all of the areas of the religion, that one which is under most pressure for reform nowadays. Perhaps it's because it's the one that most immediately impacts on people's lives. And there's no shortage of Muslim reformers who want to do away with some traditional ijma'-based rulings in the Muslim world, who will point to something like Qiyas and say, well, maybe in the Middle Ages that ruling made sense, but nowadays it doesn't, and therefore the Sharia can be modified accordingly. as I say, many voices raised to claim Qiyas for many topics, but Ijma is one of the ideals of the religion that nowadays is most seldom achieved. But if you look at Muslim reformist agendas, you'll find that Qiyas tends to be one of the topics they focus on because it has a rationalizing, also a moral dimension. It's not just God says this is forbidden, therefore it's forbidden. For Qiyas to be actualized, you have to figure out why God is prohibiting something.